Alright, somebody suggested that I read this out loud because they prefer to listen rather than read it. I'm interested because I'd like to get as familiar with this argument as possible. Okay, so I'll start at factual background. On May 20th, 2016, Deputy McIntosh was contacted by an employee at a local library. The employee informed Deputy McIntosh that a male was parked in the parking lot for an extended period of time. Deputy McIntosh observed Mr. Hines sitting in the driver's seat of a vehicle and then knocked on Mr. Hines' driver's side door. Mr. Hines exited the vehicle, which apparently startled Deputy McIntosh, and as a result, Deputy McIntosh conducted a pat-down of Mr. Hines. Next, Deputy McIntosh required Mr. Hines' identification. Mr. Hines gave his name to Deputy McIntosh, but did not provide his photo identification. After additional back and forth between the two, Deputy McIntosh informed Mr. Hines that his actions were going to dictate how the interaction continued. He told Mr. Hines he could cooperate with me by showing some photo identification, or he could be arrested for obstructing and delaying an officer. Mr. Hines ultimately was arrested for this reason. Legal framework. The Fourth Amendment provides that the rights of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. The Fourth Amendment's protections were incorporated into the 14th Amendment by Wolf v. Colorado, 338, blah, 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 and Mapp v. Ohio, 1961. A seizure without a warrant is unreasonable per se, subject only to a few specifically established and well-delineated exceptions. Katz v. United States, 1967. The seizure of an individual requires, at a minimum, reasonable and articulable suspicion. State v. Willoughby in 2009. Emphasis added. A seizure occurs, and the Fourth Amendment is implicated when an officer, by means of physical force or show of authority, has in some way restrained a citizen's liberty. State v. Fry, 1992. Emphasis added. The critical inquiry is whether, taking into account all of the circumstances surrounding the encounter, the police conduct would have communicated to a reasonable person that he was not at liberty to ignore the police presence and go about his business. Thus, the test is an objective test requiring an evaluation of the totality of the circumstances. Willoughby. It is the state's burden to establish that a seizure was based on reasonable suspicion and sufficiently limited in scope and duration to satisfy the conditions of an investigative seizure. State v. Bordeaux, 2009. It is the defendant's burden to prove that a seizure occurred. Willoughby. All evidence obtained by searches and seizures in violation of the Constitution is by that same authority inadmissible in a state court. In Mapp. Any evidence seized pursuant to an unlawful stop or an unreasonable detention is fruit of the poisonous tree and is therefore inadmissible. Bordeaux. Analysis. The analysis of this issue is governed by the U.S. Supreme Court's long-standing precedent, which provides that law enforcement may not require an individual to provide his identification unless the law enforcement officer has a reasonable suspicion that criminal activity is afoot. In Delaware v. Prowse, the U.S. Supreme Court held that except in those situations in which there is at least articulable and reasonable suspicion that a motorist is otherwise subject to seizure for violation of law, stopping an automobile and detaining the driver in order to check his driver's license are unreasonable under the Fourth Amendment. 1968. Here, there was no requirement that Mr. Hines produce identification because there was no evidence that criminal activity was afoot. An investigative detention must be supported by reasonable suspicion. It subjects a suspect to a stop and a period of detention, but does not involve such coercive conditions as to constitute the functional equivalent of an arrest. State v. DeVault in 1998. Mr. Hines was not committing a crime at the time of the encounter with law enforcement, nor did law enforcement possess sufficient information to establish a reasonable suspicion of criminal activity. Therefore, Mr. Hines was not required to produce his identification. His refusal to provide information, therefore, should be suppressed. It is true that law enforcement possess the ability, Mr. Hines, and request. It is true that law enforcement possessed the ability to approach Mr. Hines and request information. However, to the extent that the interaction amounted to a mere encounter, Mr. Hines could not be required to produce the information. In Florida v. Bostick, the U.S. Supreme Court explained that an encounter will not trigger Fourth Amendment scrutiny unless it loses its consensual nature. In 1991, emphasis added. The Bostick Court recognized that when officers have no basis for suspecting a particular individual, they may generally ask to examine the individual's identification as long as the police do not convey a message that compliance with their request is required. Emphasis added. There is no question that in this case, law enforcement conveyed the message that Mr. Hines is required to comply with the request for identification. He was informed that he would be arrested for failing to comply. Moreover, he was actually arrested for this reason. Therefore, if the police contact constituted a mere encounter, the refusal to comply with the request must be suppressed. If the police contact constituted a seizure, in other words, if Mr. Hines was not free to terminate the contact and go about his business, then the refusal must be suppressed, because no reasonable suspicion supported the police contact. Either way, the evidence must be suppressed. Finally, it is clear that this incident cannot be justified by law enforcement's community caretaking function. In analyzing community caretaking function cases, Idaho courts have adopted a totality of the circumstances test. State v. Wickham, 1997, citing Clayton, Idaho, in certain sections. The constitutional standard is whether the intrusive action of the police was reasonable in view of all the surrounding circumstances. State v. Waldy, 1995. There must be a sufficient public interest furthered by the detention to outweigh the degree and nature of the intrusion upon the privacy of the detained citizen. Citing Brignani Ponce in 1975 and Godwin v. Idaho in 1992. Thus, there exists an objective component to the analysis. The objective component is not dispositive. In addition to satisfaction of the objective test, there must also be some genuine concern by the officer to justify the detention of a citizen, and not simply the officer's curiosity or an substantiated suspicion of a criminal activity. State v. Page, 2004, emphasis added. Citing Wixom. Because community caretaking does not justify the stop of a motorist passing by an accident scene long after the accident, so the officer could inquire whether the occupants had any information about the accident. Therefore, the community caretaking exception to the warrant requirement cannot be employed as a mere pretext to permit the state to conduct otherwise unconstitutional investigations. State v. Cutler, 2006. In considering whether a search was conducted reasonably as part of the community caretaking function, we ensure that the officer's stated motives for the search were not a pretext for a criminal investigation. Emphasis added. Clearly, the community caretaking warrant exception is narrow. The community caretaking exception is a narrow exception to the warrant requirement. Thus, if Deputy McIntosh was actually motivated by a desire to conduct a criminal investigation, then the community caretaking exception does not apply. If he was indeed acting in accordance with this community caretaking function, then that function was served and over when he confirmed that Mr. Hines was not in danger. In either circumstance, the exception has no applicability to the instant issue. Conclusion: for the foregoing reason, this court should grant Mr. Hines' motion to suppress the evidence against him.